Without further ado, I'd like to introduce our Megan Ditola. The West Coast Disability Legal Center is she's the owner of this office. And I thought it would be nice, since I shared with all of you in your invites her bio, that I just tell you how I came across Megan. And one day I saw on Facebook, it was on a sister page, that they were letting everybody know about her services, and she was going to be providing a talk to sort of in the same realm for people with mental health. And I looked a little bit more into her background and found that that she has worked with people with chronic illness, and I called her, not thinking that she'd pick up. She picked up herself. She was in the airport, and we ended up talking for almost 2 hours on the phone. I had the best conversation with her. She's such a lovely woman, that she herself, as you saw in the paperwork on the bio, lives with chronic illness, and had been working to fight for the rights of a lot of our scleroderma patients. And it's just nice to know we have someone like this on our side, because I'm sure many of you can attest to the struggles of getting disability, going through the process of the denials. And so we couldn't think of a better time to offer this forum where we can have people from all over come in, which is why we thought it was important to do a combined meeting today, so she can inform everyone. So I sent everybody a confirmation email with handouts for today, and I will go off camera for a minute while she starts. So a few people who registered early this morning that didn't get it, I'll make sure that you have it too, so it'll help you follow along. Without further ado, I am going to introduce Megan Ditola, and she's going to be presenting this wonderful information on disability and documenting it, navigating the Social Security and Supplemental Security income claims process. Take it away, Megan.
All right, thank you. It's nice to meet everyone. And like Tina had mentioned, I have, just so you know, I have Crohn's disease and I have psoriatic arthritis. So I'm constantly dealing with my rheumatologist and my gastroenterologist. And as a lot of you probably know, autoimmune disorders are gifts that keep on giving. So it's not uncommon for us to have multiple autoimmune and become prone to other ones. So I know a bit more about autoimmune than a lot of attorneys, just simply because of my own experiences. Ironically, because people assume I chose this area of law because of my own illness, but I actually got diagnosed after being an attorney. I'd been sick for years, but it just kind of all went undiagnosed. But I wanted to give everyone an understanding of the different programs that are available through the Social Security Administration. Often people assume Social Security just administers a retirement program, and that's not the case. It originally started as just a retirement program in 1935 by FDR, and then it slowly evolved over time, and it includes disability benefits. It also includes something called supplemental security income, and I'll explain the differences in between the two programs. So what I'm going to talk about first is kind of the background of Social Security, the differences in programs, and then I'm going to bring it down to how specifically it relates to the scleroderma community. One of the handouts that I gave to Tina is the Blue Book listing. And the reason why I wanted you guys to have that is you'll see that it's their systemic sclerosis listing. And it outlines what Social Security requires you show to qualify for benefits. So for instance, just having a diagnosis does not qualify you for benefits. The diagnosis has to be severe enough to prevent you from being able to work. So for instance, my Crohn's disease, I'm still running marathons. I'm still out able to do those kind of things. Obviously, I would not qualify for benefits. If things ever worsen, of course, it could be a different story. So I'll give you an idea of the benchmarks that they're really looking for. A lot of times people see the listings and they think, oh, that doesn't look too hard to meet. The reality is when you look at how they define each word, Blue Book listings are very difficult to meet. So I'm going to give you a bunch of tips. So the first thing I really want to go over is the differences between the two programs, Social Security Disability and Supplemental Security Income. Disability is a program for those who have paid into the system. So for instance, your young group that you've started, they likely won't qualify because they haven't had a chance to pay into the system. What Social Security Disability is, it gives you an economic benefit, and that amount is different for everyone. It's based on what you've paid into the Federal Insurance Compensation Act, or what we call FICA. So the longer you've been paying into it, the higher your rate is going to be. The benefit with that program is you get Medicare insurance early. You don't have to wait until full retirement to get Medicare. There is a 2-year waiting period for it though. So you get the Medicare, but you still have to wait 2 years for it to kick in. There are a couple exceptions, and because scleroderma can involve organ involvement, I wanted to mention one of the exceptions. If you're on dialysis and having kidney failure, you don't have to wait the 2 years for the Medicare. The other exception is ALS. If you're diagnosed with Lou Gehrig's disease, you do not have to wait for the Medicare. And people find it unusual that there's just these two exceptions. The reality is it's been because of the lobbying groups. That's how they've been able to get that period removed. No one, again, has had success with getting that 2-year period removed. We thought traumatic brain injuries were going to get that reduced, and they did not. And unfortunately, given the state of what's going on with Social Security right now, we don't expect that to be removed for any other group. So if you qualify for Social Security Disability, unfortunately, you're going to generally have to wait those 2 years. What Social Security Disability looks at is, are you able to work for, in any capacity? And if the only way you can qualify for disability or SSI is if you can prove that you cannot earn $1,220 a month. That is what Social Security unfortunately considers full-time work. And that term is called SGA. Substantial gainful activity. So that's why Social Security Disability is considered the hardest program to get, because of how they define the standard. Other types of disability, like state disability, long-term disability, which would be if you have a program through like MetLife, Unum, a private disability carrier, they're much easier to meet. The federal standard through Social Security is much harder. The difference between this program and Supplemental Security Income is SSI is for individuals who don't necessarily have enough work credits, or they haven't paid in enough to qualify for benefits. So often SSI for most of my cases are children's cases. So I do all types of disability. So children with Down syndrome, sometimes schizophrenia, because often those people are not going to have an opportunity to work at a successful capacity. That's typically who's going to qualify for Supplemental Security Income. Supplemental Security Income gives you an economic benefit, and it gives you Medi-Cal. If you're in another state, that's often called Medicaid. Medi-Cal insurance covers a lot, but it's not generally considered as strong insurance as Medicare. So that's why ideally you want to try to apply for disability if you have enough credits, because it's just going to give you a more stellar health insurance. And the economic amount is the same for everyone at a top level, but there are certain reductions. So for this year, for 2020, if you're awarded SSI, the federal rate, and I always have to look because they change it every year, is $783, the federal rate. Because we live in a really expensive state, there's a state supplement with that, which is $160.72. So your total SSI award that you can get from the government is $943.72. But that's because SSI is a needs-based program. It's basically federal welfare. That gets reduced if you're given any in-kind support. What in-kind support can be: cash benefits from family or friends, if you're getting gifts, if someone's paying your bills for you. Automatically, if you live in someone else's home for free, they'll reduce it by 1/3 automatically. So it's a little bit of a different program depending on what your eligibility is. Ideally, you want to apply for both and kind of hedge your bets, which we call it, so you can get Medi-Medi. That's called a concurrent application. But either way, whichever one you qualify, whatever you're going through, it's the same definition. You have to prove you're unable to work for a full year or more, or your impairment is going to result in death. So terminal illnesses are automatically granted. Everyone else gets caught up in the system. So to give you an idea of what to expect when you file for benefits, the first stage is called initial application. And I'll kind of explain how things are going post-COVID and how they were pre-COVID, assuming we're going to return, hopefully, to a COVID-less society at some point. So normally Social Security offices are open. They're not. So you cannot go in for an in-person visit right now. Our hearings are all being done by phone right now with Social Security. They're not going to open up this year. I mean, more and more we're hearing it's going to 2021, which means all filings have to be done online. You can send in a paper application, but they're not really opening their mail timely. So it can be difficult for people who don't have significant computer skills. But I am one of those people. I'm a technophobe, and it's not hard to do a filing. I file probably 10 cases a week, but do not send an out paper application at this time. Regardless of pre-COVID or post-COVID, I would say don't do a paper application. The government is so overworked on these cases that when they see the paper application come in, it gets put at the bottom of the caseworker's desk. So you want to find a way, if possible, to file online. You can only file for SSI online if you're also filing for Social Security disability. So if your case is not concurrent, unfortunately, you're going to have to do a paper SSI application. The initial application stage, regardless of the type of benefit you're filing for, they will quote you taking 4 to 9 months. Even post-COVID, we're seeing things come back typically within 5 months. But expect a 75% denial rate, unfortunately. So nationally, it's a 75% denial rate. What you got to keep in mind, these are insurance programs. So it's just like dealing with an insurance company. They're going to try to frustrate you so you go away. So everyone who files, unless their illness is terminal, I tell them to kind of expect to go through the process because I don't want people to get frustrated. So you kind of have to come up with that game plan ahead of time. If you're denied at the initial stage, you have to go through what's called reconsideration. And that's for 99% of the people. There was something called a prototype case, but they're getting rid of that eventually. And that was for people who would get to skip reconsideration and go straight to the hearing. Like in Pasadena, a lot of those people get to skip recon and go straight to the hearing. We have not a new commissioner anymore. He was a commissioner who was hired back in 2019. He really has no qualifications to be the commissioner. He was a clothing maven. You can Google him and figure out more about why he was appointed and such. But he has determined that reconsideration is a necessary stage. And unfortunately, reconsideration has an 88.9% denial rate. So you're going through you're jumping through a hoop when you're going through recon. With that 88.9% denial rate, it goes back to the same state agency. And the reason why it goes to a state agency is feds do not have enough employees to process the cases at the lower level. So they contract with DDS, Department of Disability Services, which is a state entity, to work up the case. So essentially recon, it goes back to the same agency, it gets assigned to a new employee, but they're gonna rubber stamp the decision, unfortunately. So at that point, then what you have to do is go to a hearing. And reconsideration, they'll still quote 4 to 9 months, but we're seeing reconsideration come back within 90 days. So the fact that they're working from home right now has actually been a pretty decent thing in terms of them catching up with the paperwork. But even so, the stats haven't changed. We fully expect if we're going to recon, we're going to get a denial. Then we have to go to a hearing. And the hearings are at what are called Office of Hearings and Operations. There are several throughout the area. So even though you have a lot of local Social Security offices, there's not as many hearing offices. There's one in Orange, there's one in West LA, there's one in downtown LA, there's one in Norwalk, San Diego, Pasadena. But because there's not as many of them, you end up having to wait on average about 18 months to wait to go in front of the administrative law judge. Obviously, this can be absolutely devastating if you don't have work income coming in. What are you supposed to do? So here's a couple tips I wanted to give you in regards to that. Is I'm just a federal attorney, but there are some programs through the state that you can look into. So for instance, there's state disability. And state disability is a program that gives you a 1-year amount of benefits. And it's higher than what you would get generally with Social Security because it only lasts 1 year. It's through EDD, the Employment Development Department, but here's the catch to apply for state disability. I'm sure a lot of you who are on this call don't know what that program is. And the problem with state disability is you have to apply for it within 49 days of being off of work, or you lose that benefit in many instances. So when people call me saying, hey, I'm thinking of applying for Social Security disability, my first question is, when did you stop working? And if it's been within those 49 days, I say, get off the phone with me, go get on the state disability and call me back when you've secured that, because that's a use it or lose it program. And, you know, with their phone lines right now because of COVID, because they're also administering unemployment. So that same department administers unemployment. It's impossible to get through their phone lines. So you have to get that online application in. Then once you have that filed, you can call me or you can go online at any time and apply for Social Security disability. The state will often tell people you have to wait for that Social Security, that state disability rather, to run out before you can apply for Social Security disability. That is not true. And given the time frames we're talking about, I don't recommend anyone wait till their state benefit runs out before they apply for the federal Social Security disability, because that state benefit essentially is a Band-Aid. It gives you a year of benefits so you can pursue the Social Security disability. All that will happen is if you're awarded both, there'll be an offset. So they'll offset your state disability from your Social Security. It's a formula. It's basically, if you're interested, and don't worry about this, but you can never have more than 80% of what your average earnings were over the last 10 years out of all public disability. So if your state benefits, your workers' comp, your Social Security, it's more than 80% of what your average earnings were over the last 10 years, they're going to reduce some of those benefits till some of the benefits end. That's called government double dipping. But so the other tip I would give you as you're waiting for a hearing, as most people will be, is there are some situations that are called dire need, where you can have your case processed quickly. One is if you have eviction notices or foreclosure notices or shut-off notices. That's called a dire need situation. but you have to give proof to the government that you're truly in dire need. Even with dire need, it's been a bit of a situation right now because given COVID, a lot of people are in dire need. And even prior to that, we saw the government, yes, it would cut off maybe 9 months of that 18-month waiting process for the hearing, but they weren't getting people in within 60, 90 days because so many people going through the process have dire need. The other way that you can speed things up is if you have acknowledgement from your doctors that your impairment is unfortunately supposed to cause you to pass within 6 to 12 months. So if it's terminal at that point, they also will process it quickly. Other qualifiers that can speed it up, if you're a wounded warrior, which is if you were injured in combat after the year of 2001, I don't know why they don't use wounded warrior status for veterans prior to 2001, but you can also show if you're a veteran who's getting total unemployability, that's also something they're supposed to speed the case up. And if you're a danger to yourself or others, and that's a lot of my clients. I do a lot of mental health cases for schizophrenia. I have a good friend whose brother has schizophrenia, so I've kind of grown up with that. And so I'm very comfortable helping those individuals who sometimes other attorneys will not help because they're sometimes a little dangerous in certain instances, but I can show proof of my clients, unfortunately, sometimes with suicide attempts, or sometimes if they've assaulted someone and there's either a jail or prison record, I can get those cases to move to the front. So those are ways to get your cases through the hearing. Hearing statistics are all over the place. And it depends on, first of all, where you're assigned and who you're assigned to. There's judges who grant as low as 7%, and there's judges who grant as high as 60% of the cases. So it's awful to say, but in law, you can interpret it any way you want. So you have judges who are a lot more lenient than others. There's a disability website, if any of you are going through hearings right now and are assigned to judges and you want to see their statistics. It's called www.disabilityjudges.com. And through the Freedom of Information Act, these judges' statistics are posted online. No one knows who runs this website. I do think it probably is a Social Security attorney, but no one's going to acknowledge that they're publishing stats on all these judges online, but it is a good resource to have an idea of what you're up against, given the judge you're assigned. I'm going to be honest, I overwhelmingly like the majority of my judges. So I've been a Social Security attorney exclusively since 2004. And regardless of the president who's been in office, I haven't noticed a lot of changes in the judges. I do like the majority of them. Of course, there's always going to be a few bad seeds, and that's in any type of area of law or any type of profession. But I do feel the majority of judges do try to get it correct. Don't be weary if you see the statistics online are very low, because I have some judges I absolutely adore whose statistics are, they're only granting 20% of the cases. And the reason being is you have to meet the definition to qualify. So people will come to me all the time who I'm really sympathetic towards, but they don't meet the Social Security standard of, can you perform any work in the national economy? And this is what Social Security looks at. And we'll stay in the hearing level right now. I'm going to tell you about some follow-up stages in a second. But number one, are you working? And that is, are you working enough to earn $1,220 a month? If so, you're not disabled. And just so you know, those are gross earnings, not net earnings. The second thing they look at is, do you have an impairment that's severe enough to meet one of the Blue Book listings. So that's one of the handouts I have for you. The Blue Book listing for systemic sclerosis is 14.04. So that is the criteria that you have to generally meet to qualify. There's a couple ways around that, and we're going to get into that in a little bit. But generally, it's got to be systemic sclerosis. It cannot be localized. They're not going to give benefits for localized unless you have other impairments in addition to that. So what then happens is they look at your ability to work. So can you do your past work? If you're under 50, you have to be able to prove that you cannot do a single job in the national economy. If you're over 50, they do start looking at transferable skills. And that's the last criteria. Can you do your past work? If not, can you do any other work in the national economy? So that's how you have to prove your case, okay? If you're denied at the hearing, the reality is that's close to the end of the road. There are appeal stages, like for instance, there's appeals counsel, which is the next stage. That stage has a 92% denial rate. So we've got judges who are all over the place, but if you get denied at that stage, you're gonna have to go to appeals counsel. Your chances of getting benefits are slim to none. I have not seen them reverse a decision in quite a long time. I've had a couple remands, but generally you gotta win by the hearing level. Your final option, if you're denied at the appeals counsel stage, which appeals counsel can take them anywhere from 12 to 24 months to make a decision, and then you can file action in district court and go in front of a judge through the Ninth Circuit eventually. And it'll depend on your court, whether you're central district, Southern District, Eastern, Western, or Northern. But generally speaking, to take it to that far, you have to have a seamless case. Because the problem with taking things to federal court is if we lose, we can create some really negative precedents that then follow claimants throughout the process. So that gives you an idea of what to expect. A majority of people are going to go to the hearing level. But what I wanted to then get to, and if you want to grab your listings, is the SSA listing on systemic sclerosis. So that's how they categorize scleroderma. And it's going to tell you what you have to meet to qualify, to meet their definition. So if you want to grab that 14.04, and this can be a very useful tool for your rheumatologist because often they're not aware of the criteria. I'm always talking to my rheumatologist. I actually talked to him this week on a Zoom call about kind of the changes in law, what to expect with his patients, because he's often surprised that some of his clients or some of his patients are being denied. And I always am hitting him over the head. There's really strict criteria that you have to meet to qualify. And unfortunately, the reality is we're really reliant on the doctors to give letters of support to help a claimant get through the process. I'm sure some of you might have gone through the process. And what happens is Social Security can send you to one of their doctors. And these doctors, unfortunately, don't want to bite the hand that feeds them. So often they're going to side with Social Security. The reality is too, they're not often provided your medical records to take a look at. So often you're going in for a 15-minute examination and that's it. That's all you're going to be dealing with. And that doctor is going to say you can return to some type of work. So generally what we try to do is get your rheumatologist, and I say rheumatologist because Social Security is not going to give a whole lot of weight to a GP. Immunologist also could be someone who could do a letter of support, but you want them to address why you meet this 14.04 listing. Most commonly, what we're seeing cases that get granted are most commonly diffuse scleroderma, where we're seeing organ involvement. So that's often where we're seeing some congestive heart failure, unfortunately, some pleuritis in the lungs. We're seeing kidney failure because the government understands organ failure. So often the cases that most commonly are granted are those who are having organ involvement. The other way that we're seeing a lot of cases get granted is if you do have the contractures or the deformities in joints. So in your hands, in your feet, so they can actually see why you would be unable to do work. One of my clients, she was really young, and so this was pre-COVID, and so at the hearing, she's had a lot of contractures to her fingers, and it's quite obvious that she would not be able to write or type or do anything like that. And this was with a very tough judge. And the judge, when we went in there, right away started hammering, because she was only like 36 years old at the time, started hammering at us. And I had prepared my client. I said, if you're okay, I want you to just show the judge your hands so she can actually see what you're dealing with. And it shamed that judge. I said, Your Honor, I said, just give me 1 minute. And I asked my client, I said, can you show the judge your hands? And you could tell the judge was ashamed of herself for going that hard. But you got to keep in mind that these judges, they don't write their decisions. They have their hearings. They don't really prep their files. They have clerks and attorneys who take a look at the files for them. So a lot of times they're not really familiar with these conditions. Like a lot of my judges don't know the differences between osteoarthritis and rheumatoid arthritis. So you've got to hit them over the head so they'll grant the case. The other things they'll take a look at, you'll notice in the listing, fatigue's important, but it's really hard to prove your fatigue is severe enough to work. And so what they'll often say is, well, have you had a neuropsychological evaluation to show that your fatigue prevents you from doing simple repetitive tasks? Well, it's very rare that a claimant's going to have that done. It's a very, it's a cognitive test that shows you're going to have problems with memory or focus or attention, because that's what they're really looking at is cognitive fatigue. And then another thing they'll look at is weight loss. But even though it doesn't specify in this listing, well, how much weight loss qualifies, there is a weight loss listing under the digestive disorders. And what they're really looking at is, do you have a weight loss where your BMI is under 17.5? So it used to be 18. What 17.5 is, to give you an idea, I'm 5'6". I would have to weigh like 108.5 pounds for my weight loss to be considered profound enough to meet the weight loss listings. So that's why often we're coming at it from the contractures or from organ involvement, showing that there's been a lot of problems. I try to get my clients to always, when they're starting a disability case, whether it's for sclerosis or whether it's a different type of disability, if there's a blue book listing, I try to get my clients to give it to their doctor ahead of time. So the doctor starts documenting your symptoms in the record. So this can be used to help you, because you want letters of support, but you also want the clinical notes to show that you're exhibiting these types of impairments. The other thing I want to give you as a tip is don't rely on the government to get your medical records. So when you apply, they're going to have you fill out a form where you list your doctors, you list your medications, but they're not going to, unfortunately, always get those records. Like certain facilities can be very difficult to get records from. Like UCI can be a tough cookie to get medical records out of. So Social Security will send one request, and if the doctor doesn't respond, they're not going to follow up. So they're not going to follow up. Keep that in mind. So what I tell all my clients to do if they're on their own, I do a lot of counseling for people I don't even represent. And so I'll tell people how to be successful on their own so they don't need to get an attorney. Often I tell people, you know, I'm here if there's a complicated issue, but I have no problem advising people in terms of what they should do if they're applying on their own. And that's the big thing, is get your own medical records and submit them to the government, and then get your own letter of support. Other tools you can use, and if any of you have been through the process, there's something called a residual capacity form, a residual functional capacity form. That's basically Social Security speak on how much can you lift, how far can you walk, how long can you sit, would you have unscheduled breaks? And the reason why is this is exactly what they have their doctors fill out on your behalf in terms of what their doctors think you can do from just looking at your medical records or from that 15-minute evaluation. So if your doctor would be willing to do one, that really helps you in your case. Problem is certain facilities will not do these forms more and more. Number one, they're not generally getting paid for them, so that a lot of facilities won't take the time. But also more and more, because of litigation and things like that, doctors are afraid to sometimes make statements on behalf of their patient in terms of disability, because we see this a lot in orthopedics is, well, what if the patient claims the back surgery I performed made that individual disabled? I don't know if I want to go on the record saying the claimant's disabled. So it's something that you have to have a conversation with your doctor. I call it a crucial conversation, saying, I'm applying for disability. Would you be open to help? The other question to ask ahead of time is, do you think I am disabled, or do you think there's some type of work that I could do? And if so, you know, if the doctor thinks you're still able to work, sometimes the doctors can give you resources if you're struggling, to like vocational counselors or things like that can help rehab you back to work. That's always my goal, is that Social Security disability is a temporary Band-Aid for people, that you may have to use it for a short period of time. And then when you're out of your flare or rehab yourself to a different type of occupation, then at that point you go back into society and you get off the disability. But the reality is there's just some disabilities that unfortunately people don't improve from. So it's hit or miss. One thing to prepare you in terms of how timeframes have changed right now, and this is kind of interesting to me, is I actually think things are moving quicker than pre-COVID. So if you're applying, it's a good time in that sense to get an application in. The bad news is that the government is seeing a lot of applications from people who are not disabled, but have just been hurt by the economy. And so they're applying for benefits right now because they've lost their job and maybe their unemployment has run out. So I'm expecting the floodgates to kind of open with cases where people may certainly have impairments, but they don't meet the government's definition of disability right now. So it's just something to prepare yourself for. I don't know how it's going to change over, let's be honest, it's going to be at least the next 7 months. I don't think things are really going to change COVID-wise till minimally March. I know they're saying a vaccine is going to be available, but is it going to be effective? We don't really know. So that's another thing to just give you an idea. See a doctor regularly. So this is important too. And I know it's depending on your insurance. Is a lot of times, like, I can treat myself at this point, basically. Like if I'm sick or I'm Humira, I take Humira and methotrexate, but if something's bad, I can just call my rheumatologist and say, hey, listen, I might need a little more methotrexate. Like I feel like I'm going in flare. I don't want to, but I think I might have to do prednisone a little bit because things are flaring up. Like my doctors know me so well that I don't always have to go in. But if you're looking to apply for disability, you have to be seeing your doctors. So if they see you're just treating with a GP and you rarely see a specialist, they're not going to take it seriously. And the other thing is there's a rule called failure to follow prescribed treatment. So if your doctors are prescribing things and you're not taking them, unfortunately, that can be a problem with the case. It's not so much an issue with surgeries because they understand like surgeries are something you really have to think about. So your doctor may recommend, for instance, a fusion, but you don't have to necessarily do the fusion. But if the doctor's recommending a medication and you're not taking it, Social Security is not going to be really keen on that. I mention that because I know a lot of people are very nervous about some of the biologicals or the chemo agents. But if you're taking just kind of over the counters, unfortunately, the government's going to say, well, clearly it's not severe enough to prevent you from being able to work. Keep track of all your paperwork with Social Security. They do lose forms on a regular basis, so never send them originals of anything. One thing to prepare you for this right now, if you were born in another country, what they're instructing people to do if you apply for benefits is to send in your original birth certificate. Do not do that. They're going to tell you to do that. You will never see that birth certificate again. So when they're asking me to do that with my clients, I'm just giving them a photocopy for now and then saying when they reopen the door, my client will walk in and show them the birth certificate and they can mark it in the system, but do not give them any originals. Always keep your copy. Get a name of anyone who you deal with at Social Security, and if you can, get an extension for their phone number. They do not like giving out their phone numbers. So you'll notice sometimes they'll call you and they'll just give you the generic 800 number, which you're never going to get through to your caseworker. So try to be demanding to get an extension anytime you talk to them, because it's important to be able to get in touch with them and stay in communication with them. That's drastically important. If you return to work, let Social Security know too. Otherwise, if you're on benefits, you can get saddled with what's called an overpayment, where they'll come after you for the money that they've been giving you. And just so you know, these impairments, and I know we're getting close on time, so I'll leave time for questions, but the one other thing I wanted to say is, just know these applying for these benefits, sometimes people feel shamed by it. And I never understand really why, because number one, disability is something you pay into. It came out of your paycheck. But it's also something that doesn't have to be permanent. It's something that you've paid into to help yourself, should you become disabled. And ideally, you hope you improve over time. And then at that point, you just notify the government. There's different programs that they can do a return to work. It's called a trial work period, where you test your ability to work for about 9 months before they stop the benefits. But it's not something you have to be on permanently. But if you're in a situation now where you really can't go to work, and your rheumatologist is telling you, or your immunologist is like, I don't think it's a good idea, you're getting worse, you're gonna flare up your symptoms, look into this as a possible solution. It can be a temporary Band-Aid, and you can go from there. So that's what I really wanted to just give you an idea of what to expect with these benefits. I know it's a lot of information, and I honestly could speak for probably 3 or 4 hours. I do some conferences that are that long, but we just wanted to give you an intro course right now, since we can't all meet in person. I'd be happy to answer questions or talk about specific topics that are unique to your community, but ask away. I've handled over 2,500 cases, so there's really not something I haven't seen at this point. So. And Tina, should I take some questions and see?
Tina, you're still on mute.
She may be registering people still.
Yes, sorry about that. Can you hear me now?
Perfect.
I needed to be co-host again so I can see the question, so I couldn't get back on because it wouldn't let me. Okay, so I have one question here. And thank you, Megan. I wanted to tell you, if you needed more time, we do have time, because we took up about 15 minutes when we did our opening.
Perfect. I can go into other topics, but maybe the questions will generate it and I'll go from there.
Yeah, I think that I would like to allow you because it might end up actually answering some of these questions. So why don't I give you the floor a little bit longer and then we can go into it because we do have time.
Okay, perfect.
Thank you.
So a couple of other things that I wanted to talk about, if possible, were some of the other types of cases that are out there. Because often, you know, I don't know how common this is with scleroderma, but my type of impairments often get diagnosed before the age of 30. And since you guys are starting a branch for kids and for a juvenile system who gets diagnosed early, there's something that's called, they used to call it adult disabled children's benefits. What they call it now is children's insurance benefits. And it's a bit of a misnomer. It's actually for adults, but it's for adults over the age of 18 who were disabled prior to the age of 22. And you're applying for Social Security disability even though you don't have enough credits. And what you're applying on is on a parent's work number. So you can apply on a mother or father's work number, or a parent who adopted you, and sometimes a grandparent who adopted you. If the parent is either disabled themselves, if they've retired, or if the parent has passed away. The key with that program, though, is you have to prove you were disabled prior to the age of 22. So if you don't have medical evidence prior to the age of 22, and out here, doctors tend to only keep records for 10 years, unfortunately, that's going to be a problem. The other thing is you cannot be married. You can't have ever worked substantially, meaning on a monthly basis for 2020 earning $1,220. So that's just something to keep in mind, but that's a benefit that's out there. And then there's other types of cases that you may come across, like just to give you an idea of the climate with Social Security. So Social Security is supposed to review cases every 3 to 5 years. They have not historically done that because they don't have enough employees. Over the last year, we've seen more reviews than we have ever seen in the whole time I practiced this area of law. And the reason being is there's a new proposal to review the majority of cases every 2 years, even if there's not expected to be improvement. And so that's a bit of a problem in terms of what to expect, because often these reviews happen, you're given a little bit of time to respond. And let's say your doctor's out of town and you can't get a letter, they'll cut you off your benefits and you have to go through the whole process again. So what I'm telling everyone is the first notification that they're getting that they're reviewed, try to get your doctor to do a residual functional capacity form, update form, saying that you can't do an 8-hour day of work, or try to get a letter. Some doctors are more comfortable with narrative letters, and get that to them right away. Because the reality is you're likely going to be sent to a Social Security doctor. And unfortunately, chances are that doctor is going to conclude you can do some type of work. So that's it. Those are called CDR cases, continuing disability review cases. There's also cessation cases, which are very similar, where you'll just get a notification that your benefits are being stopped at that time, and they're not reviewing the case. And at that point, unfortunately, it also triggers these same review processes where you'll have the right to go through reconsideration and then have to go to a hearing, but you're going to be going through the same process like you did the first time. A question I often get from people is, what happens if I applied for these benefits years ago and I want to apply again now? Can I do that? You can, but it's more complicated the second time around. And the reason why, there's something, it's this fancy Latin word called res judicata, and it means claim preclusion. So essentially, you've gone through the process once and you were found not disabled. So it is presumed that you continue to not be disabled. The way around that is you need to show a significant change circumstance. So a common change circumstance that we can get around that is a new impairment. So let's say you originally applied where you're more having problems with just the skin aspect of scleroderma, but now you want to reapply because you're having organ involvement. We can argue that that's a worsening and it's a changed circumstance. Or let's say you have an additional diagnosis on top of it. Let's say you got diagnosed with Sjogren's on top of it, which can be kind of common. You can apply with that new impairment. The other way is you can come through it from a different age category. So what Social Security does is they put in ages, and they're a little offensive of how they term it. So I'll go through it with you. If you're under 50, it's called a YI, a younger individual. And you have to prove you can't do any work in the national economy. But 50 to 54 is called closely approaching advanced age. If you're in a new age category, that's a changed circumstance. So that's a way we can reapply, saying, well, yes, maybe we couldn't prove the person couldn't do any past work, but we can prove the person can't do their current job as a longshoreman. So that's closely approaching advanced age. 55 and above is advanced age. And that is the easiest category to be granted in. On average, the people who get granted are at 54 years of age and 8 months. So that is the majority of people are granted are in their 50s. It's that difficult to get benefits if you're under the age of 50, unless you concretely meet that blue book listing. But when I was saying there's sometimes ways around that blue book listing, that's what I'm meaning is if you're in one of those categories where you're over 50, if you can't do your past work and you don't have transferable skills to a lighter type of work, that's called gridding out. So that would be for the community 50 and above. The heavier the work that you did, the easier it is to get benefits from that gridding provision. I do a lot of work with motion picture because that's such a heavy job for like the local 80, they're called grips. They're the ones who move the equipment around, they set up the sets, they rig the lights. It's a requirement that they lift 150 pounds at their job. So when they're have an autoimmune condition or they have an orthopedic condition, if they're over 50, I can very easily get them their benefits because they can't do their past work and their work is so unique to motion picture, they don't have transferable skills to other industries. You can't say because you can rig up a set, you can go build a house. So the more unique your work is, the easier it gets if you're over 50. It's very difficult if you're a skilled sedentary worker because to prove you can't do sedentary work can be very difficult. But that's why often coming at it for contractures in your hands or swelling, you can't type, you can't write, that's all got to be in your medical records. The other thing I want to caution people too, because I'm one of these people and my doctors always tell me to stop being so smiley. But when I go to my doctors are like, how are you? And I'm always like, I'm fine. I've got no problems. I'm just kind of used to dealing with like the normal pains of autoimmune. I'm an endurance athlete. I ran my first marathon when I was 17. So I like pain. I'm someone who actually doesn't just tolerate pain. I like putting myself in episodes of pain. But as my doctors have explained to me, there's good pain and there's bad pain. And sometimes when my doctors are like, how are you doing? And I'm like, you know, I feel fine, everything's great. And then like I'll get x-rays on my feet and they're seeing there's more damage from the psoriatic arthritis. And my doctor's like, you're not being honest with me. Like you're coming in all kittens and rainbows and unicorns, but I can't help you if you're not going to be honest with me because I have a unique rheumatologist whose wife's an endurance athlete. So he works with me to keep me running and biking. But on the agreement that I'm honest with him because obviously if I start having the joint issues. So it's very common for people to put on that brave front, but if you're wanting to apply for Social Security disability, you have to be honest with your doctors. So it's put in your medical records. So because that's how Social Security makes the decision. When you apply, you're going to get all these forms that are called function reports, where they ask you about how you're feeling. I'll ask a family member how you're feeling. They don't care about those reports. It's just to show they're working up the case. That you still got to return them, because if you don't return them to them, they're going to say you're not cooperating. But you want to make sure that it's your medical records that have all your symptoms in there, because that's what they base the decision solely on, 100%. So if you're going in every time saying everything's okay, and then you look at your records from your rheumatologist and it says, patient great, no symptoms, no pain, see me in 6 months, well, the government's going to say in their decision, patient says everything's fine. So you're applying for disability, but you're telling your doctor everything's okay. So even before you file, what I tell my clients to do is go get a copy of your medical records. If you're applying for Social Security under the California Health and Safety Code Act, you're entitled to 1 free copy of your medical records. Get a copy of them and take a look at them and see how things are being documented. Certain institutes are better than others at documenting records. Kaiser's great in terms of treatment, but unfortunately, their records system is what they do for that is they kind of compile everything at once. And so it follows your history for years. So what happened in 2004 may still be part of your history in 2020. And that could be problematic if things had advanced. So you got to let your doctors know, hey, I looked at my records and this isn't accurately reflecting what I've been saying. And they'll go through and update the history if you let them know. So you got to take a look at those records before you even file to see what's going to be going into Social Security. And that's generally what you want to be most careful at. Your decision on your case is going to be only on those medical records and medical reports, and also in terms of Social Security's own doctor's opinions. At the hearing, it's the judge's right to have experts there. Almost every judge is going to have a vocational expert there. But some of the judges are also going to have medical experts there. A lot of the medical experts are retired. And a lot of the experts, I'm going to tell you right now, are not going to be very familiar with sclerosis. They're just not going to be. They're also not going to be familiar with the new advent of medications right now. So often you're going to be dealing with a doctor who may not be terribly educated to your condition. And 9 out of 10 times, the Social Security judge is going to adopt what the Social Security medical expert says. So you got to make sure your records are strong enough that the judge will side with your doctor opposed to the Social Security doctor. Or the other side of that is to make sure the Social Security doctor then says, well, I'm reading the records, they're well documented, this person meets this listing, and then you win your case. So that's the other thing you want to be careful with is there's going to be experts at the hearing. People often ask me, can we bring our own witnesses? And there has been a couple rheumatologists that I've been able to have come to the hearing. Generally, that's not going to be a common thing. I've had it just because they were great patient advocates and they were curious about the Social Security system, so they volunteered to come for their patient. But most doctors, to take a day off of work to go to a hearing, would charge you tens of thousands of dollars to do it, to be an expert witness for the day. So you're not commonly going to see that at the hearing. So you're basically going against a judge who is paid by Social Security and 2 experts who are paid by Social Security, and then you have yourself in just that record that has been documented from your doctors over the years. The other thing before hearing, you have a right to look at an Exhibit CD. So if any of you are in the hearing process right now, these Exhibit CDs are not being sent out. If you're waiting and you're close to your hearing, request your Exhibit CD from the court so you can see what the doctor has and doesn't have. So those are kind of the main things to expect in terms of when you're going through the process. It's document your symptoms, make sure you have concrete diagnoses. So if you know, for instance, your joint damage is getting worse, like you can tell very much with your condition, just like I can with psoriatic arthritis. I see it in my feet when my right foot has been flaring up a lot and I can tell I'm getting the swelling. Well, go get a new set of x-rays to show that there's more degeneration taking place. Like I always tell my clients, like, you know your body better than your doctor. Your doctors are great, but I'm sure a lot of you went through that whole song and dance trying to even get an accurate diagnosis at first, where a lot of us get misdiagnosed before they figure out our exact autoimmune. So if you know something is going on and you're looking to apply for Social Security, make sure you go through the testing, go through and have your blood work done again to see if you have the inflammation markers in there, if those have increased. Those are all different things you can do to establish disability, but listen to yourself on that. And those of you who may be newly diagnosed and are just trying to figure out what to do and get good medical care, doctors are hit and miss. I've had some great rheumatologists. There's some that aren't so great in terms of it. And push until you get a care provider who is working with you to try to better improve your life. If you've got someone who's looking at their watch every time you go in there at 10 minutes, they work for you. Find yourself a new doctor. I mean, you should be comfortable speaking to your doctor, because if you're going this disability route, you need to have a great team on your side. But again, too, with your patient care, if your doctor's not really listening to you, it's time to find a new doctor. We live, thankfully, I'm assuming most of you on the call are in California. There's a ton of providers out there, and it's hit or miss. My GP, it took me 10 GPs till I found a GP I like. So, you know, who I can work with, who's okay with me doing my running and the things I want to keep doing. So just that's the other thing, is you're going this route, you've got to have good advocates on your side. Witnesses, though, in general, besides the doctor, it's just going to be yourself testifying at the hearing. They don't care what your family has to say. They don't, even if that person's a witness for you. They don't care what third parties have to say. And it's the only time we really use outside witnesses is for seizure disorders, because someone can witness those seizures, or for mental health. So you've got to kind of prepare yourself for testifying. What I do with my clients is I do pre-hearing conferences with them before the hearing. And depending on the judge, like, it's hard for my clients because I'm generally pretty friendly. But like, if we have a tough judge, I'm like, I'm going into judge mode and I'm going to be slapping you around. Well, we ask questions to get you comfortable with it. But then that day of the hearing, they'll feel much more comfortable when they're in there, because they're going to say, oh, I went through that with Megan. And I'll be snarky, I'll do the eye rolls, that whole thing, because they're just administrative law judges. They're not real Supreme Court justices. They're just me, just so you know. They're just attorneys who took a multi-examination and got, you know, that's all you do is you take a multi-choice test, you go for an interview back east. So unfortunately, when you're not being vetted to that degree, unfortunately, people come in with their biases. One thing we're seeing this year, which I've been very impressed with, is our Supreme Court, where everyone thought the Supreme Court in the United States was going to turn very much politically, and it has not, because those jurists are being exactly what they're supposed to be, is objective. They're following the law, even if it doesn't align with their personal opinions, because they've been trained. That's how they got on that bench to be Supreme Court justices. Unfortunately, in this area of law, they're just attorneys like me. And sometimes people cannot put their personal opinions on a side, and it clouds the judgment. So you've got to come in there ready to fight, because we don't know what we're up against sometimes when you're assigned to a judge. All right, so Tina, let's take some questions.
Okay, I'm going to start with a couple that came in via email for you.
Okay.
One was, after I was laid off of my job at age 68, I went on unemployment for 6 months. My scleroderma was okay, but then flared. And shortly after that, I was hospitalized, and I was diagnosed with stage 4 lung cancer. So I went on disability for 12 months while turning 69. Then they told me I couldn't collect disability anymore after the 12 months. So when I was 70, I decided to go ahead and start collecting Social Security because I didn't think I had a choice. She wants her question is, doesn't disability go on 12 months? Should I have appealed this?
No. So what it would have been on was you would have been on EDD, which is the state disability. And that does last a maximum of 1 year. So you do only get that for 12 months. Unfortunately, Social Security disability is a pre-retirement benefit. So once you're at full retirement age, which is for most people 66 now, they've been raising their retirement age, you no longer can apply for Social Security disability. You can apply it if you're on early retirement, which you can take after the age of 62. But once you are at full retirement age, even if you haven't collected the benefit, because my dad had a very similar situation, waited till 70, severe lung impairments, but he would not be eligible for Social Security disability because the fact that he was past full retirement age. So he would have had to apply at 65 before he was at his full retirement age of 66 to collect the Social Security disability. Once you're at 66, your only option is to apply for retirement. Another good point based on that question that I just want to bring up is people often ask, well, what happens if I'm on disability when I hit that full retirement age of 66? And keep in mind, Medicare 65. So you have to apply for Medicare at 65 or you get penalized. But for Social Security disability, most people's full retirement age is 66 now. But what happens automatically is once you hit full retirement age, they convert you to retirement, where they start calling it retirement for statistical purposes, but you keep whatever rate is higher. So if your disability rate was higher than your retirement rate, you're going to keep that disability rate, but they're going to start calling it retirement. They just prefer that label. If your retirement was higher than your disability rate, you'll be increased to that retirement rate. And it's all based on how you pay into FICA. But for that individual's question, no, because the state only gives you a full year of benefits. There's no extensions on that. And unfortunately, she would not be eligible for Social Security disability because she's past full retirement.
Okay, makes sense. Thank you. Okay, next question. I understand that if we provide our medical records, it can help expedite the decision. What format do they prefer? Hard copy, paper file, CD, electronic file?
You're going to see me turn red on this question because this is one of the things that frustrates me with Social Security. They're requiring basically everything by paper at the lower levels until you get what's called a barcode. So if you can get your DDS analyst to give you a barcode, you can electronically submit the records to them at the lower levels, but often you can't get in touch with the DDS analyst. At the hearing level, there's a different type of barcode, and you can submit things directly into the e-file. That can be really difficult for people if they don't have a scanner that handles a lot of paper. Like most of my clients' files are about 3,000 pages. But I don't like sending in paper medical records because you're at the mercy of Social Security taking the time to scan them in. They'll often pretend they haven't received them. They disappear, poof, in their offices. So I try to add things to the file. But a big issue that we've had is like certain providers, like everything's electronic, like Kaiser gets everything to us electronically. We're not allowed to send things to Social Security by thumb drive or CD or any of these other mechanisms because they're really afraid of viruses. And so often you're stuck unless you can scan in a lot of information, and there are limits on their files. For a document to scan into the e-files, it's like 50 megabytes or whatever that term is at the end. So often you have to break down these records. So they make it very difficult. They're not user friendly. There's no iCloud accesses or things like that that we can transfer it to. But I would demand a barcode. And what you do is you put the barcode on top of it. You can either e-fax it in that way, but just know it's only going to take 50 bytes at a time. So you kind of sometimes have to divide up records. I'm constantly using like these, you know, adapters to compress my PDFs to try to get them in as one document, because sometimes I don't like separating the documents. I think it confuses the judge.
Thank you. Next question. If you have multiple doctors at one facility, such as Kaiser, do you need a separate medical release for each doctor, or is there one that you can give for the entire work for Kaiser?
Kaiser is great in the sense that there is, if you even go online and say Kaiser medical release authorization, there is one paper that you can use for everyone. So even when you do your application, I wouldn't even list it by doctor, list it by facility. But what you do when you request those records, you go on it, there's going to be a box on top and it says from what facility. Just type in all Southern California locations. That will compile all your records. A lot of times too, we're dealing with physical issues that can cause depression. So it's not uncommon for us to be seeing therapists or psychologists or psychiatrists. Just especially know with Kaiser, if there's some mental health records you want to come in, you have to check a separate box on that form to have those included, because those are more sensitive information. So they're very careful about holding those records back. But generally you want them to come in. You want them to see how this is affecting your life. I know sometimes that can be embarrassing or uncomfortable for people, but you've got to be an open book. You've got to let them know what's going on. So let them know how this has affected you from a mental standpoint. Most individuals who deal with chronic disabilities do have some degree of depression associated with it.
Thank you. Third question, does Social Security still offer face-to-face interviews with the claims representative, telephone interviews, or are they doing it now, or do you do it yourself online?
So you can do it online. You can also set up an appointment with them by phone, but they're still not allowing in-person evaluations. We're thinking that's going to be through 2021. So if you're not comfortable using a computer, you certainly can call them and schedule an appointment. They're running a few weeks behind because they're all working from home, and it took a while to get them all the equipment, but they're doing a pretty good job with it. I got to give them credit compared to other areas of law, especially they were not ready for this at all, because like most of their employees didn't even have access to email. There's no cell phones for them. So the fact that they adapted this quickly, I give them a huge pat on their back. Most cases in other areas of law, they're delaying trials till next year. Our judges are doing our hearings by phone. So they're finding a way to try to get people their benefits. But you unfortunately cannot go in their office, and don't expect that to change soon. It's not just the fact that it's dangerous for people to come in, it's also the liability. What do you do if it's contact traced that someone picked up a virus at Social Security? As a lawyer, I can tell you people are really scared about the lawsuits that are going to come down the line from people being exposed to COVID. Unfortunately, my office shares a floor with a walk-in clinic, so it's not an ideal situation right now, but depending on the impairment, I'm still meeting people in the office, but I'm just giving people that warning that, hey, we have a walk-in clinic. I don't know if someone's walking in there with COVID. So, I think the government's too scared to have in person at this time.
Thank you. Next question. So we have one of our members on today that's actually in the hospital while waiting to have transplant and continues to be denied, and she wonders why.
Okay, so are you? I'm going to assume it's probably a kidney transplant. You would automatically.
A lot of our patients get lung, and I believe it's lung.
Okay, a lung. You should automatically qualify for the benefit if you meet the technical definition. So what happens is if you don't have enough credits of coverage, you may not qualify. SSI is for the other program for people who haven't paid into the system, but you have to have less than $2,000 in countable resources to qualify for supplemental security income. But if you do not have a recent work history, you may not be eligible for Social Security disability. So generally, out of the last 10 years, you have to at least have 5 years of work to qualify, or 20 out of 40 credits. You can get 4 credits a year, so that's why it's 20 out of 40 credits. So it's sounding to me like it's likely a technical denial that you don't have a recent work history, or you don't qualify for SSI if you don't have the work history because you have more than $2,000 in countable resources. And for SSI, they look at your income in your household. So if you have a spouse that works, that's going to preclude you from SSI because it's going to be above the resource limits. The other thing that can be the problem is if you worked for someone who didn't pay into FICA. So for instance, like if you were CalSTRS or CalPERS, they've changed a bit now where I think they're allowing people to pay into FICA now, but there's a lot of agencies that opt out, like LA Unified School Teachers, they don't pay into FICA, so they're not going to qualify for Social Security disability. Some police forces don't pay into FICA, so they have to look under their own pension plans and such. So that's the other thing, that if you maybe worked for an entity that didn't pay into FICA, that could be the issue too. But medically, you would definitely meet the definition.
Thank you. I think when I look at this next question, I think I know what he's trying to say. I'm working at an established job. I don't think I can get a new one. I have several diseases and look bad on paper, but feel okay. How long should I wait to apply? But I want to add something to that because I know that there's people who maybe do get at some point the benefit and go on disability, but then they might start feeling better and go back to work. And then they try to apply later and they get denied. So I thought maybe you can kind of summarize both in this because I know that that's happened and I want your thought on that.
Okay, so what generally you do, so if right now you're working but you're telling things you can tell things are ramping up and that you're starting to get worse, be proactive in starting to lay the groundwork. So that's where I'd start having those crucial conversations with the doctors, making sure they start documenting in your record that you're having increased symptoms. If you're thinking of applying and you're noticing your joints are changing, here's where you'd want to go have updated x-rays to see what's going on, or MRIs to see what's going on. Start getting the plan in place, knowing that you may have to stop work soon. And then the other thing is if you were on benefits in the past and are back on and you're looking to reapply, you absolutely can. You can, as long as you paid back into the system, that's what this is for. I've had some clients who have been on disability 3 or 4 times for these type of impairments. Or another common one is I've had clients that had cancer and they got it for a time period and then the cancer was in remission for years and then unfortunately came back. They can reapply. So it's not use it once and lose it. And then you want to just keep in mind that if it gets to that point that you're going to stop working, the first thing I do is also talk to the doctor and find out, I think I'm at this point where it's getting pretty bad. I'm struggling to get out of bed in the morning. What should I do? If the doctor says, well, we should look at disability, find out how supportive the doctor's going to be. Because often they'll do the state disability forms, but won't be terribly helpful with the Social Security forms and such. And just say, would you be willing to help me out if I need more than a letter? I understand it's gotten much tougher to get benefits, and see how the doctor responds to it. But if your doctor says to you, unfortunately, like, I don't think you're disabled, I think you're going through a difficult period, that's kind of you know that you're not going to be very successful to apply because you're not going to have that doctor's support going forward. And then what's going to happen is you'll get railroaded by Social Security's doctor and you're not going to have a way to combat it, unfortunately. So start getting your ducks in a row. I mean, I try to just always keep my records in a row to begin with. Like I'm very good about like seeing my doctors when I have to. Like my medications cause a lot of skin cancer. I've had skin cancer 4 times. I had to have my whole face slice open with a Mohs procedure because of it. So like I get that done every 4 months now because I know it's a big issue if you're on biologics. So start going to see all the doctors that you may need to start establishing a case.
Thank you. And what about the ones that have went on it, started doing better, went back to work, and then their disease is flaring up and they need to go back on disability? Many of them are denied and have a very difficult time. What's your thoughts on that? And by the way, we have about 5 minutes before let them. We've got several questions.
Okay. Yeah, unfortunately, the reality is you might have been on it in the past and it's gotten much more difficult to get benefits now. The laws have changed, the administration has changed a little bit, and so it's much harder to prove. So you may have flown through the process even a decade ago. I mean, I started doing this in 2004. It used to be much easier to get things to go through. Don't get frustrated if you get denied initially. We expect it. And unfortunately, you're just going to have to pursue it all the way to the hearing level. I know that's easier said than done because basically I'm telling you, you've got to find a way to support yourself for 2.5 years. That's how long it really takes from initial application to get up to the hearing level. But as frustrating as it is, it's expected now. And so sometimes what happens, and the government counts on this, is you get that letter denying you benefits. And keep in mind, you only have 60 days plus 5 mailing days to appeal the case. People get frustrated, they throw that decision away because they're just like, I don't want to deal with this. The letters are written in a rude way that it kind of marginalizes you, where it'll make you feel shamed. But just know it's you're being told by an insurance company. That's all this is. A Social Security is just an insurance program, to go away because they're going to see if you do. So it's very common to get frustrated, and that's what they're counting on. They're counting on the fallout to save the funds. The reason why it's gotten much harder, I'm sure most of you guys know this, but what happened is when this program was started, it was not supposed to be touched, and since the money that was in the fund for both retirement and Social Security, well, the government started borrowing from this fund. And then all of a sudden, the baby boomers especially, started retiring, and there's not enough money to pay everyone. So the government's like, pump the brakes. We don't have enough money to pay everyone, so they're getting more difficult. They have to give the retirement, so they're getting much more difficult on the disability case, trying to replenish the fund. And that's what we call some of the judges who are really conservative, where they're never going to give benefits. They view themselves as gatekeepers of the fund, and they'll do what it takes to protect the fund.
Thank you. I work for the city and don't pay into Social Security, then have to go. So what I go through the city system, I did, and I think what she was trying to say is that I have paid into Social Security maybe at another time, but it hasn't been, I think, consistent is what I'm understanding.
Okay, and yes, you would apply through the city because unfortunately, once you stop paying in the system, your benefits expire after 5 years. So if you last worked in 2005 paying into FICA, your benefits expire in 2010. So if the disability is ramped up after that, or you return to work after that expiration date, unfortunately, you're not eligible for Social Security disability. So you would look at your employer's policy, their own disability plans.
Thank you. What happens if you move to a new state in the middle of filing?
That's fine. So these are federal benefits. So you can go to any state you want. You can go to any U.S. territory. You can go to Guam. You can go wherever you want for it. The one thing I'd let you know is that state supplement with SSI, that $100 and change, that's unique to California. So if you're an SSI recipient, your benefits could be reduced if you move to a state that doesn't have a supplement. The other thing, once you're on disability benefits, we do have reciprocity with other countries. So I even have clients who live out of the United States now. So as long as you can move, you just got to notify them that you've moved. For SSI, though, the one that's the federal welfare program, you cannot be out of the United States for more than 30 days because it's a federal needs-based program. That's why.
Thank you. Does TPN, which is total parental nutrition, so it's through a line to get their nutrition, or any feeding tube automatically qualify you for disability?
It doesn't automatically qualify you for it, but you should be able to get benefits. You might even come at it from, because you're speaking my Crohn's language, you bring it into the digestive listing. So that is actually one of the qualifiers for my disorder for IBD, is TPN is one of the qualifiers for that. So what you can do, even if it doesn't exactly align with their listing, you also can equal a listing saying, my condition's a little different than how you outline it, I would equal it. So let's say you're missing some of those criteria from the Scleroderma listing. Well, then I'd argue, yeah, but I meet some of your digestive listings. So absolutely with TPN, that's very serious, understandably, and I'm sorry you're dealing with that. Absolutely, that would be something that you should consider applying for.
Thank you.
Unless it's real short term. If it's something like you're going on for a week or so, but if it's long term TPN, okay.
She's long term. Yeah.
Okay.
Long term, for sure. Thank you. Last question. Are hearings held by video or just phone?
So right now we're doing everything just by phone, and the reason being I don't think the judges are really comfortable with us seeing their homes. But in normal process pre-COVID, you have an option to an in-person hearing, or to speed it up sometimes you can agree to have what's called a VTC, a video hearing with a judge. Depending on the jurisdiction, sometimes I recommend it, sometimes I don't. Like, I love my Long Beach judges. So in my jurisdiction, I tell my clients to object to a VTC because I want to have one of my judges I know. But certain jurisdictions that aren't great, like West LA is not a great jurisdiction, I'll take any judge. You know, it doesn't make a difference to me. So we will take a VTC and get whoever we get quickest, whether it's by video or in person. But right now, everything's by telephone at the comfort of your own home, but no video.
Thank you. I have a couple questions coming in, but we're running out of time. So I would like to know if I can email you the remaining questions, and would you be willing to answer my questions and let me, when I do my recap to everybody that signed on today, that I can share that information with them?
Absolutely. I have no problem doing that.
Great. And I want everybody to know we're recording this. And once we do any final edits that need to be done, because a couple times when camera somehow goes to other people in between, once we get it all cleaned up, we will send you all the link to watch it in its entirety. And maybe there might be some key things that you were trying to take notes, and this way you can take your time and just go through the recording and make your notes. And I'll also make sure that everybody has your contact information if they're ever in need of your services.
Perfect.
Okay.
Perfect. I will get your questions answered.
Thank you very, very, very much for doing this today. You have no idea how long this has been something on our mind, and you did a beautiful job breaking down these details that nobody else would probably ever give them the opportunity to hear. So we feel very honored to have you today, and I hope you know how much we appreciate your time today.
Absolutely. I'm more than thankful. If you ever have any additional questions, I'm always around, so ask away. And thank you for allowing me the time to tell you more about what I do.
Thank you very much, and I hope you have a great rest of your weekend.